This is Left Voices for Thursday, April 10th, 2014. I'm Andrea Sears. Tonight,
what we've already seen is a number of providers of abortion have had to stop providing abortion care, and as a result, women have had to travel miles and miles to get to an abortion provider.
Advocates seek review of a ruling upholding a Texas anti-abortion law. Abortion rights advocates today filed a petition with the U.S. Court of Appeals for the Fifth Circuit asking the full court to reconsider the constitutionality of a law that is forcing some clinics in Texas to close or stop offering abortion services. The law, called HB 2, requires abortion providers to have admitting privileges at a hospital within 30 miles of the facility where abortions are performed. A federal district court judge ruled the law unconstitutional, but a three-judge panel of the appeals court overturned that ruling, allowing the law to go into effect. The American Civil Liberties Union, Planned Parenthood Federation of America, and the Center for Reproductive Rights are asking the full panel of Court of Appeals judges to acknowledge that the law isn't designed to protect the health of women. It actually hurts them. A fact that Bridget Amiri, staff attorney at the ACLU's Reproductive Freedom Project, says the three-judge panel of the court didn't seriously consider.
With respect to whether the law would further patient safety, they said that the state didn't actually need to come up with any real evidence to show that the law would further patient safety and women's health. But if that was a plausible reason for passing the law, then that was enough. And that simply can't be right.
Is there evidence that would indicate otherwise, that having this law in place could actually endanger the health or safety of women in Texas?
Well, absolutely. So what we've already seen is a number of providers of abortion have had to stop providing abortion care, and as a result, women have had to travel miles and miles to get to an abortion provider, pushing them later into their pregnancies where abortion is less safe than earlier abortion. And the consequences have literally been devastating for women in Texas. The American Medical Association and the American College of Obstetricians and Gynecologists oppose admitting privileges laws, even though they might seem reasonable on their face. Those major medical organizations understand what we know to be true, which is that these laws don't actually further women's health, but instead could detrimentally harm them.
Are there other procedures like birthing centers or anything like that that could conceivably require admitting privileges based on the same logic or reasoning that the legislature applied in this case?
So there are no other attempts to require providers of other types of health care to have admitting privileges, which shows that abortion is just being singled out because of the hostility to abortion in this country. So there has not been any attempt, and in fact, one of the judges in the Seventh Circuit asked the attorney for the state of Wisconsin, why abortion? Is it because it starts with the letter A? And it's that kind of arbitrary nature of the targeting of abortion that is very real.
How many abortion providers were in operation in Texas before this law went into effect, and how many would be forced to close by this law?
There were approximately 36 abortion providers before this law took effect, and after the law's effect, there are now approximately 24. The number keeps changing, however, because some doctors have been able to secure privileges while others have lost them, and it is a changing landscape. But what I will say is that there are huge parts of the state without an abortion provider. All of southern Texas and all of West Texas lack a single abortion provider.
There are other states where similar legislation has been passed and has been rejected by the courts. Alabama, Mississippi, Wisconsin. What were the differences there?
Well, I think that we're introducing the same type of evidence, but you're absolutely right that there has been good decisions coming out of the Alabama District Court. We got a good decision from the Court of Appeals in Wisconsin, and those courts, I would say, followed Supreme Court precedent and asked the question about whether the law actually does, in practice, further women's health.
So when you go to the en banc court, will you present new arguments? What will be your approach?
Well, this petition that we filed today asks the full Fifth Circuit to rehear the case. So first, the Fifth Circuit would have to take the case and rehear it with all of the judges. And our basis for asking them to take the case as a full court is that the panel decision conflicts with Supreme Court precedent that says that laws have to further women's health, and there must be absolute evidence to show that that is what happens in practice.
Are there similar legislative efforts going on in other states? This bears the earmarks of one of those American Legislative Exchange Council bills that pops up everywhere they can possibly get a legislator to introduce it.
You're absolutely right that there are a number of copycat bills, and this is part of the anti-choice playbook of how to pass laws that restrict abortion in your state. And so we are seeing parallel bills being introduced and considered in other states, including Louisiana, for one, that I'm aware of right now.
And is this something that is likely to be further appealed up the line by either party, depending on the outcome?
Yeah, so you do have to consider every step of the way kind of what your next step is, and so we have to take it as it comes. But certainly already the Wisconsin appeal is pending for a petition to ask the Supreme Court to take that case. So we were able to get a very good decision from the Seventh Circuit Court of Appeals, and the state of Wisconsin has asked the Supreme Court to take that case.
Are there other challenges to abortion rights and reproductive health rights that are currently coming up that could have an impact on this or other cases in the future?
Absolutely. Things are in dire straits right now for the state of reproductive rights in this country. We are absolutely inundated with a number of bills that we're seeing across the country, both this year and in the most recent years prior, that restrict access to abortion. And there are a number of court challenges to these restrictions, but it's not enough. Women and men have to get involved in their communities and try to prevent these laws from being passed in the first place.
There's been a complaint that Roe may not have been based on the best possible basis for guaranteeing abortion rights in the United States. Is there any way that this can be solved either legislatively or judicially to help stop this onslaught of challenges to women's right to abortion?
It's an excellent question, and if I knew the answer, then we would be in a much better place. But I do think that we have to continue making our voices heard. In terms of the courts, we will continue to present arguments and evidence to show that these laws are not designed to protect women's health, and instead shutting providers down does just the opposite, and it harms women. And we'll be presenting different legal arguments, not just the right to privacy, which I do think is a solid basis for the right to abortion, but also alternative constitutional arguments as well.
Bridget Amiri is Senior Staff Attorney at the American Civil Liberties Union's Reproductive Freedom Project. This has been Left Voices for Thursday, April 10th, 2014. You can help support this experiment in independent journalism by visiting our website at www.leftvoices.net and following the Ways to Support Left Voices link at the top of the page. Join us again tomorrow for more news and information from a progressive perspective. I'm Andrea Sears for leftvoices.net.